Hi, I'm Ryan Reed, a family law attorney here in Kentucky. When I meet with parents who are beginning a custody dispute, the first, most urgent question on their minds is always, who will get the kids? For a long time, the answer to that question was complicated, often unpredictable, and could lead to lengthy, expensive court battles. But in 2018, the legal landscape in Kentucky underwent a major, important shift with amendments to our main custody statutes. This change created a legal principle that every parent needs to understand: the rebuttable presumption of joint custody and equal time sharing, equal parenting time. And this isn't just a technical rule, it's the default starting point for every custody case in our Commonwealth. Understanding how it works is key to successfully navigating your divorce or custody matter. A presumption is a legal assumption that a judge must make unless proven otherwise. Now, if a judge is deciding things, the judge must begin your custody matter with the assumption that joint legal custody and equally shared parenting time, that's a 50-50 split of the schedule, that is in your child's best interest. This has a profound impact. It places both parents on equal footing from the moment the case begins, eliminating any historical or perceived bias toward one parent being the default primary resident parent. It also strongly favors joint legal custody, meaning both parents share the equal right and equal responsibility to make major decisions about the child's education, health care, and religious upbringing. This makes equally shared parenting time or physical custody the default, meaning the court will aim for a schedule that equates or maximizes the time the child spends with both parents. Now, crucially, however, this is not a guarantee. The word rebuttable means you have the opportunity and the burden of proof to overcome this presumption if you believe that an equal split is truly not in your child's best interest. The legal standard is still the best interest of the child. The 50-50 presumption merely sets the initial bar. If you or the other parent wishes to push for something other than an equal time-sharing schedule, you must present enough evidence to convince the judge that another schedule would better serve the child's best interest. The court will consider a comprehensive list of factors, but I want to highlight three of what I think are the most critical areas where the presumption can be successfully challenged or rebutted. First, domestic violence and abuse. This is the most crucial factor. Under Kentucky law, if a domestic violence order, or DVO, has been put in place against a parent, then this presumption of joint custody and equal time sharing does not apply to that parent. The court removes the 50-50 starting point and then proceeds to weigh the best interest factors. Now, a judge could theoretically still wind up giving a 50-50 schedule, but it is far, far less likely with a domestic violence order in place. Second are practical and logistical barriers. While not always enough on its own, logistics really can make a 50-50 split unworkable. The court is focused on the child's adjustment and their continuing proximity to their home, their school, and their community. So, for example, if parents live hundreds of miles apart, a true 50-50 schedule becomes impossible because of how it severely impacts the child's school attendance and social life. Also, highly irregular or erratic work schedules that conflict with the child's basic needs can be persuasive evidence against a 50-50 schedule. Third, the parent's motivation and cooperation. This shared parenting law places a very high value on cooperation. A judge will specifically look at the motivation of the adults and the likelihood a party will allow the child frequent, meaningful contact with the other parent. If one parent can demonstrate through documented evidence that the other has a history of trying to sabotage their relationship with the child or refuses to communicate about basic co-parenting issues, the judge may conclude that an equal shared parenting arrangement will likely result in high conflict and instability, which is virtually always detrimental to the child. The rebuttable presumption has fundamentally shifted strategy in Kentucky custody cases. No parent can simply assume that they will be the primary resident parent any longer. One way of thinking of this is that both parents now need to demonstrate how they can effectively co-parent and why their proposed schedule, whether it's a 50-50 schedule or some deviation, why that best serves the child. I find that this shared parenting approach in the custody laws actually encourages parents to be responsible, cooperative, and highly involved in their child's life from day one. That's a good thing. Now, if you're beginning a custody dispute, it's absolutely essential to consult with an experienced Kentucky family law attorney who can help you strategically gather the right evidence, either to support the 50-50 schedule or successfully rebut it with the specific facts of your case. And if you think that Reed Law Group could be the attorney for you, give us a call. We'd love to hear from you. Thanks for listening.